This is our Smartcast for September 17th, 2013, Employees and Social Media, what employers really need to know. Now, we put a lot of case law into this, and the last time we did this, I looked back, and it was right around the beginning of 2012, so it's been a while. And my, what a sea change of activity, both on the legal front, but also in terms of just things that employees are using and you as employers are using in the way of social media. This presentation, as of pretty much all of the ones that we do on the Smartcasts, are really to protect you as an employer. We do these to alert you to things that either are new or maybe you didn't know because they're old and buried, but they're still the law. And so this will be the change there. I hope we don't keep getting that annoying little thing there coming up. So here's our agenda. There's really three topics that we're going to cover. We're going to look at social media from a Section 7 of the National Labor Relations Act point of view. But we're going to spend quite a bit of time talking about what that really means right now as we go into, in a couple of weeks, for 33 states that have federal health care exchanges, or are supposed to. Actually, none of them have any. And the 17 remaining states that have private exchanges are, some of them are really good and ready to go, and there's a couple of them that probably aren't going to make it out of the box on October 1st. And we're going to kind of talk about that issue, which is a real issue just days away that could affect this. We'll look at the lawful definition of what protected concerted activity is. And then we're going to take a look at a really old law that you probably never heard of, and I must say I never did either, but in the research I said, there are a number of lawsuits that are starting to come out under the Stored Communications Act of 1986, and I think you'll find it kind of interesting in terms of what it means for you, again, right now. So with that, why don't we look at concerted activity. A concerted activity, the operative term there is concerted. It means that employees are joining together. They're joining together to do something. And in this case, it's about employment. Now, this the verbiage here, I'm just going to read it for you. This comes directly from an old law, but nevertheless, it's an accurate law, and it's still one that's enforced. And it's the Wagner Act of 1935. It is the law that legitimized collective bargaining. Before that, there was a lot of gray area about unions, and employers and employees were not exactly getting along very well. That thing is going to drive me crazy. And so Congress intervened, and President Roosevelt signed the Wagner Act. That also is known as the National Labor Relations Act. And that created a whole bunch of sections and a body, and that body is called the National Labor Relations Board. Let me read this for you. Employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining. Now, right there, I'm just going to stop and say that's basically how unions came into being. Now, the National Labor Relations Board historically has been pro-union, and not necessarily not politically necessarily, but that was really their meal ticket. There were so many problems in the collective bargaining process, and just the way that was all set up, the NLRB really had a big role in unionism. Well, as we all know, probably in our lifetime, we've seen year after year, union membership has declined, with the exception of the public sector. That has an area that has grown. But private sector unionism has declined in our lifetime. And it doesn't seem like it's going to ever return to the glory days. So what has happened with the NLRB is that they have turned their attention, because you can read this thing very specifically and say, well, actually you don't have to be a union member. I mean, this is just employee protection. But it happened to apply to a new concept at that time, which was collective bargaining. That was new to the country at that time, and at least on a legal sense. But this is the part that I really want to draw attention to. So we've talked about that employees have a legal right to bargain, to form unions, and that's what that's all saying. But then there's this conjunctive term here, or other mutual aid or protection. Now that's the big thing that what the NLRB is doing today. They are going very much into designing programs, promulgating regulations, and using existing statutes to protect non-union employees in your company. Now, I don't think this is on the web page. I probably could have checked, but because I grabbed this earlier in the year for something else I was working on. But this was on the NLRB's website earlier this year, and it says the NLRB's webpage targets your employees. They're not a friend of the employer. They are the friend of the worker. They're a friend of the employees, your employees. The law we enforce gives employees the right to act together to try to improve their pay, working conditions, or fix job-related problems, even if they are not in a union. If employees are fired, suspended, or otherwise penalized for taking part in protected group activity, the National Labor Relations Board will fight to restore what was unlawfully taken away. So kind of not too much to read in between the lines there in terms of where they're coming from. Now hold that thought that you have this, this federal agency out there that is there to protect employee rights in the workplace. That's it. They go home, NLRB doesn't go home with you. It's only at work, and they're there to protect your employees. So all the employee rights that your employees have, a good chunk of them are under the governance of the NLRB. Now, what is a protected employee activity? Well, the NLRB wants to know if this is violated, but let's talk about what it is. And there's some cases here. The PowerPoint, you can go into FON and go under Smartcasts, and you'll see that the PowerPoint's in there. I'm actually running this out of FON right now. But here was a case, Kaiser Industrial Corporation back in 1992 versus the NLRB. Now you notice that who the plaintiff is and who the defendant is, the NLRB. The plaintiff is the company, and what happened was there was an employee who said, I think this is an infringement upon my rights, and they went to the NLRB, and the NLRB says, yeah, we agree, and so why don't you just kind of step aside, and we're going to come in there with legions of deep pockets from the federal government, and we're going to have lots of attorneys, and we're going to represent you and get what we think was unlawfully taken from you. And that's how it works. Do you think you can beat the NLRB? Not, I wouldn't think you'd want to try. What happened in this particular case, employees jointly, this is all they did, they asked their supervisor for clarification of work assignments. There was some role conflict, some lack of clarity, just on what they were supposed to do. And they go, we're not really sure. You weren't clear or something. And would you please just tell us clearly what we're supposed to do? Well, apparently, well, not apparently, what would happen was, if I just put this little piece in here, but if you read the whole case, you'd find that the employer kind of got bent out of shape about that. And at least this manager did, and felt you should know this, and what was unclear about what I told you, or it didn't go very good. And so those employees got a real bad time. And so they contacted the NLRB, and the NLRB came and says, you know what, shame on you, employer. Those employees were simply asking for clarification of the operative term, work. Work. It has to be work-related. Mass advertising and publishing. 1991, employees essentially presented a grievance together. Now, this is a concerted activity. They got together in concert. They went to the employer, and they said, you know, we all think that this is wrong, and this is a work issue, and we would like to petition you, in essence. This is not a union deal, but we would like to petition you to change this because we don't think this is a good thing for all of us. We all think this is a bad thing, and it's not for the betterment of the company or the employees that work here. The employer got angry again on that one. This is usually the way it works. The employer gets angry. Why do they get angry? Because they don't know better. And that's what this Smartcast is all about, to know better what those employees' rights actually are, clearly where the boundary lies. Now there's some other ones here I'm not going to go through, but I put them in there for your personal edification. Now what is a lawful, protected, concerted activity? Protected employee activity, now we've added a term here, concerted. This is when employees get together. It's a three-part test. Anytime your employees come to you, the antenna should go up, and at least, for this three-part test. Number one, is an employee coming to you, or employees, plural, are they coming to you in unison? Are they united around some kind of matter, some sort of an issue that they want you to address? It may be very minor. It may be something just horrible. It may be something ridiculous that you're going to say, no, we're not going to do that, because you've got rights too. But if they come to you, the antenna should go up that, oop, this is a concerted activity. And then the question is it lawful or not? The second thing, so if the answer here is yes, okay, well, proceed with caution. Number two, when the employees come to you, and they come to you together representing one person speaking on behalf of others, does it seek to benefit other employees? So is it like, this only benefits me? No, this is something that I think we should do. I would benefit from it, but so would everybody else or a whole group of employees. If the answer there is yes, what their employees are seeking does benefit other employees, that is another thing that says, this sounds like employee rights here. The third question, when the employees come to you, is it carried out in a way that causes them to lose protection? So are they dealing with the matter here where the employees are going to be the worse off if it is not addressed? They're going to lose something that they already had. And if the answer is yes to all three of these questions, you most likely right there and then can say that you are dealing with a lawful, protected, concerted employee activity under Section 7 of the National Labor Relations Act. Now stay with me, friends, because we're going to take this thing right down to ground zero here in a second. Now here's this is the same verbiage from the very first slide, and again I wanted to just emphasize that employees have a right to go to their employers, is basically what this is all saying, for unions and all that other stuff, or other mutual aid or protection. What is mutual aid or protection? Well, mutual aid could be, there's a couple people here we feel they're being unfairly taken advantage of or treated poorly or something, discrimination, whatever it could be. And so we think it's wrong and we want you to change that. Or it could be for the personal protection of the individual. So it's one person that's getting an unfair shake, and everybody else is coming to that person's aid and saying, we think this person's not getting a fair deal here, and we're all here to say we think that's wrong. We're in concert together. Here are some examples of protected, concerted employee activities that went bad for the employer. Now, those of you that are on this particular call, you're probably not the people that I really should be targeting with this information. It's really your managers and your supervisors, the ones that have immediate contact on a day-to-day, hour-by-hour basis with your employees. They're the ones that, time and time again we hear this, you've got to train your managers, train your supervisors, but we don't tend to do that. So and the common law is pretty replete with that. It's not the HR people that are messing up. It's the people that don't know anything about HR, like this stuff, that don't know any better. So here's a situation. 5 construction employees were fired after several of them appeared in a YouTube video complaining of hazardous working conditions. What do you think? 5 construction employees appear in a YouTube video, kind of out there in the public marketplace, complaining about hazardous working conditions, and they probably mentioned their employer. Do they have a legal right? I mean, they're kind of hanging their employer's dirty laundry on the line. The answer is yes. The NLRB says that is a lawful, protected, concerted activity. It may be incredibly embarrassing for a couple of managers and certainly for the employer's name, their brand, but it's lawful. Number two, a customer service representative is fired after discussing wages with another employee. Well, we all hate that, don't we? You never talk about wages. That's one of those taboo topics. In fact, in this particular example, it was in the handbook. The handbook says you should not talk about wages. Well, wages are kind of, that's kind of an employment situation, and particularly if there's a lack of internal equity, if the wages are really out of line, or if there's some unfairness, some sort of discrimination that's going on there. Well, in this case, the person was caught discussing wages contrary to what the employee handbook said that they could do, and that person was fired. NLRB says, you know, that person, that's a working condition matter. They're trying to better themselves or their fellow employees. That's exactly what the NLRA is set up to do. Big fines. Now, in these first two that we've looked at here, and you're going to see these in the rest of these, I want to point out something else. 5 construction employees complained. A customer service representative talked about wages with another employee. And apparently what happened, you don't have to read too much into this, but the employer interfered because they took a opposing view to that particular action. In doing so, they violated Section 7 of the NLRA, and that's that they interfered with the employee's rights, their federal rights to engage in protected concerted activity. But there's something else that happened here. In these cases here and these other ones too, not only did they interfere with their rights, but then after all was said and done, they terminated the employees. They terminated the customer service representative. That falls into a different area of the law, and that's called a retaliatory strike. It's retaliating for what the employer thought they could do, which was to keep squelch on this thing, keep it under control. But in reality, the law says, no, employees have a right to do that. And if you interfere, that's a fine. That's a violation. And it's a big fine. Big fine. Then if you retaliate, well, that's even worse. That's another violation. 2 violations. Want to keep on going? And that's a bigger fine. So when if you interfere and you retaliate, bad things happen. A paramedic fired after posting grievances about her supervisor on Facebook. Here we go. Following a work-related incident. Fired. Well, a grievance? Is that so bad? An employee fired and threatened with deportation after he delivered a petition protesting their poor living conditions and irregular hours that were that was signed by several dozen welders who were performing contract work under temporary visas. This sounds like maybe an immigration type of an issue. Now, whether or not they were eligible legally to work in the United States or had an H-1B visa or a green card or whatever their status was, those issues aside, the NLRB still is interested in anybody working in the United States and having their rights in the employment world being violated. There's 2 issues here. One is their legal status as a person to work in the United States. The other one is the fact that they are working and they still have to be treated carefully. So you can't have undocumented workers working for you, but if you do, you still have to treat them. You can't have a different standard on how you treat them versus citizens of the United States or people that are documented. 2 women fired for telling a newspaper that they, along with a group of poultry workers, oh boy, this doesn't sound good, walked off the job to protest a new requirement that they pay 50 cents per pair of latex gloves when they used. two women were fired for going to the newspaper. Went to the newspaper, and they were fired by their employer for saying, you know what, this is not a safe situation handling a lot of poultry with your bare hands. It's not safe. It's not clean. And this really would fall actually almost under PPE, personal protective equipment, under OSHA. So the fact that and even though 50 cents is sort of a de minimis issue, the fact that the employer made them pay for that, the NLRB says, no, no, no. You're wrong, employer. You have to do that. And by the way, they were right in taking a protected concerted activity. And even though they went to the newspaper and hung it out for everybody to see and make you look maybe not so good, they still had a right to do that. They have a right to do that. And that kind of brings us, it brings us to really where we're at today. Here's where I'm going to shift gears. Most employers use LinkedIn. They use it a lot. My company uses it a lot. I know lots of my customers use it a lot. They use it a lot with me. My employees use it a lot with our customers. And that's more of a business thing. Social media is also Facebook. Now, Facebook, as we know, is incredibly, at the moment, just really red hot. A lot of people use it. I use Facebook. Maybe you use Facebook. Now, we pretty much, beat this to a pulp here, what a protected concerted activity is and what is an employee right that they have. Now let's take out a situation that is about to happen. There was a survey that was done. Now we're talking about healthcare reform and social media. There was a large random sample of employers for the whole U.S. This is back May or June, and it was recent is the point. And the statistic I'm going to give you is not important either because I don't exactly remember what it was, but I think it was 83%. It was a big number. And the question was, in the face of healthcare reform, what is your ACA strategy for dealing with employees to accommodate the Affordable Care Act? And again, that number I think was 83%. It was 80-something. I know that much. So let's use the number 83%. 83% of the employers in the United States said we are going to cut employees' hours to get them under 30 hours so that they fall off the eligibility list. And therefore, we are not going to be fined, nor are we going to have to provide them health insurance. And that's how, from our point of view, we think this is going to be an incredibly expensive thing. And we're going to save some money by doing that. Now let's think about those employees that are affected by that, because that's a large number. 80-some% of employers saying they're going to cut that. Which, by the way, if you did that only in and of itself and not part of some other downsizing, you're also in violation of ERISA 510. But you can go on FON and listen to that Smartcast from a couple months ago. Now those employees that so many employers said we're going to cut your hours and take you under 30 hours, it's really a subterfuge to avoid the purposes of the ACA. Are those employees going to be happy? Probably not. They've lost income, because they've lost hours, and they've also lost health insurance. That's a double whammy. How far-fetched is it to think that they're unhappy and they're going to come in and talk to their manager or somebody that will listen to them to try and seek redress of their plight? I don't think that's very far-fetched at all. I think that'll be almost universal. They're not just going to take it on the chin and not say nothing. They're going to say something. And because you're dealing with somebody's health insurance, and that's probably the bigger one actually than the actual pay, that's pretty personal stuff. So very easily, those could be your employees. That could be your company that cut people's hours. And now they come to you and they say, wow, did I get a raw deal on this thing? Remember, there's a few people that are affected by this, but even if there's just one, if they come and say, look, I am exercising, I'm not going to say this, but they're exercising their right to approach you and say, let's get this, we're at loggerheads here, and I want this resolved. Chances are that discussion's going to get, kind of a little bit out of hand. Maybe it's the manager. It's the manager they report to. Does that manager know the stuff we're talking about today? Probably not. And so that person will be kind of angry, especially if there's with a few people. Then you get kind of a mob mentality going. And so they complain about that. And then they go on Facebook. And they go, you know, boy, my employer, I used to be a good place to work. They cut my hours. They cut my health insurance. I thought we were supposed to be able to keep our health insurance. This is all messed up. And my manager is so-and-so, Joe Blow. And Joe really mistreated me, and I tried to address this with him, and he was just real adversarial and all this kind of thing. Mentions Joe, mentions the manager by name, maybe mentions another manager or supervisor by name, mentions the company by name. And then, because of just the way it kind of works from a social point of view, a lot of times one of your employees on social media may have some of his or her friends at work also being friends on Facebook or other social media. So they chime in there and they go, you know, I had the same thing. I had my health care taken away from me, and they made me go out there and give me these health insurance exchange notices, and there's at least in 33 states, there's no exchange to sign up for. This thing is really messed up, and the employees are very unhappy. This could be your situation here in a couple of weeks. I hope not, but it could be, and that's why we're talking about this. So now, you catch wind as an employer, or your manager, or your supervisor, they catch wind that one of their reports is out there bad-mouthing the company and bad-mouthing them personally. And they call them in the office. Again, is that going to be a happy conversation? No, it's not. But those employees have a protected right in everything they did, as long as they were doing it to try and better their working conditions, to better or to get back something that was taken away from them in their workplace. Now, if the employer, if your manager, who's not trained on this, or supervisor who doesn't know this, if they start saying, you know, well, this wasn't my idea, I didn't make this decision, and basically not being considerate of the employees, if it crosses that line to where they're interfering with their right, violation, big fine. And if that manager's kind of a hothead, maybe doesn't have a really good relationship with those employees, and demotes them or somehow does something that's not in their best interest, fires them, now you've got retaliation. That's a second violation, and that's another. These are huge fines. These are not like $10,000 fines, my friends. These are big fines. So I want to make you aware of that. Now, here's a law that you probably never heard of before, but you certainly know of the concept. And this is called the Stored Communication Act. It was 1986 when it was passed, a long time ago. And you're probably familiar with the concept. But the concept, now this is a two-edged sword. It cuts both ways. The way it's cut for many, many years is that it protects you as an employer from employees who should not have access to maybe email or maybe how about protected health information. You know, that only a few people in your company should have access to that. And if people see that, you're in trouble. So if somehow they break in or they get a password or something like that and they get access to stuff that they should not be authorized to do, well, you have recourse under the Stored Communication Act to say, you know what, you're not entitled to see that. And however you got in there, we want to know that, but never, the crime has been committed. And it is a crime. It's a federal crime for you as an employee to break into your employer's system or somebody else's system where you know you shouldn't be in there, and you somehow got a password from somebody and you really shouldn't have it. That doesn't mean you can just go in there and do it. You're still going to be guilty. Now, when I said it cuts both ways, what about if that employer who finds, and this was the case here with Rodriguez, a case that was earlier this year actually, Rodriguez versus Widener University. And here's what it says. There was I'll just give you the gist of the situation. There was a student employee at Widener University. And the student employee alleged that his employer obtained access to his Facebook account and then suspended him because he was perceived to be a threat to the community due to posts displaying images of weapons. Sorry, folks, after what we had yesterday. But that's what it was. And the employer moved to dismiss the complaint, la-di-da-di-da. Well, what happened here was the employee used this, or at least his attorney, used the Stored Communication Act to say, you know what, this goes both ways. The employer should not have access to the employee's Facebook password and username. But somehow they got it. Maybe they got it from one of his friends. Who knows? We don't know. It doesn't matter. They knew that they really shouldn't have access to that. He didn't invite them to be a friend on Facebook. So they got it through some other means. And that means was protected under the Stored Communications Act. So, my friends, be careful. And they lost that case, by the way. They lost that case. Be careful when you're dealing with all of this social media and employees using social media for legitimate reasons for your business, and then all of a sudden they're doing personal things. And then when they get upset, that seems to be where they vent today. This is a social phenomenon that we're living through. And so they vent on these social media channels. And as long as they're talking about work stuff, saying that my work isn't going well and my boss is a jerk and this needs to be changed, that is protected concerted activity. You should not have access unless you were given access to look at that. And even if you do have access and you look at it and you go, holy my, they're saying terrible things about managers here in the company, and this could affect us, our business, our employer, our customers are going to look at this and think we're just terrible people. No, they have a legal right to do that. And so, healthcare reform could bring on more social media, could trigger some of the events that we've talked about, but even if they didn't, social media is here to stay, probably for the near future, and we have now looked at this and how this affects your company and how it could affect your employees, your management, and certainly your risk of litigation. So I'm going to take some questions, and if you have any, so let me see if anybody raised their hand. I will gladly call on you. While you're thinking about that, I'm going to see if we have any questions. Okay. Well, I don't see where we have any questions, and we shoot for 45 minutes. I thought we'd have some questions, and we're now at 40 minutes, so we're pretty much right on the money. So having no questions, I want to thank you for letting me be a part of your afternoon today, and wish you all the best. And please fill out that evaluation and get it. We'll just fill it out and click send. It'll come right back to us. And we look forward to having you. We're going to be doing a sexual harassment in November. October next month, we'll be doing one on the Military Leave Act. So a lot of stuff happening on that hasn't been really publicized a lot. So that might be a good one for you to when you see the invitation, please sign up for it. Thank you, everybody, and have yourself a great day.